Good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez, and I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney. In all cases, the city has the burden of proof. The city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city attorney will swear in all witnesses.
Anyone that's going to speak on these matters today, you can stand up, raise your right hand, or be sworn under oath. You swear the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? Okay. Thank you. There's one other person that's going to be coming in. I'm going to have to swear him.
Okay,
Swear
sounds
okay.
good. Tom, just let me know, Mr. Trask, when that person comes in and
Okay.
before we get to that person, and I'll make sure that he gets sworn in.
Thank you.
All right, the first case on the agenda today is case number 2024.3724 for the property located at 14133 North Bayshore. Is the city ready to proceed?
Yes, we are, and this item is now in compliance. The property owner did pull the required building permit Friday afternoon. And so we're removing this one from the calendar.
All right. Okay, we will move on to the next case is case number 2023.3665 for the property located at 13062 Gulf Lane. Is the city prepared to proceed?
Yes, and this property is in compliance as well. They came into compliance just after the notice went out. The permit has been issued for this one as well. So we're removing it from the calendar.
All right, we will remove that second case as well. All right, we will move on to old business. The first case we'll deal with is 2022.3526 for the property located at 590 Normandy Road. Ms. Trask, is the city ready to proceed on this one? I think this is a request for an extension of time. Is that correct?
That's correct. It's the motion that is pending based on the filing made by the property owner, Mr. Vestgarten, and he's in the audience today.
All right. Mr. Vestgarten, you here? All right, come on forward, sir, and just for the record, give me your name and address. And then this is your motion, so I'm going to let you go first and tell me what you want to tell me, and then Mr. Trask can respond.
Tove Vestgarten, 590 Normandy Road. Filed a motion for extension of time, and most of it is covered in the motion. The one thing that changed from last time I was here till now is the city made a ruling for allowing the shaded structures. So now I'm applying for those permits and taking a little bit longer than expected, but it's in process. Marsh has been very helpful with all of that. So hopefully we have that taken care of within the next month or so.
So you're asking me to give you more time to come into compliance? Is that what you're asking me for today?
Yes.
All right, Mr. Trask, how do you respond to this motion?
So the property owner was given 90 days. Well, first of all, this case came before you in February. We are now at the end of August, so 6 months have passed. Mr. Vestgarten was given 90 days to come into compliance. In the original order on March the 5th, he was given another 49 days to come into compliance in the order that was entered on May 24th. And now he's seeking another 90 days to come into compliance, which would put this thing out at 7.5 months to obtain a building permit, and that's just not acceptable to the city. The city would object to any further extensions being given.
All right, and Mr. Trask, since I'm with you, I'll start with you. Is it just the building permit for the Cheeky Hut, or is there some other permit or other approvals that the owner needs to come into compliance?
So he was cited with a violation of section 86-52, failure to obtain a building permit. So the building permit is dealing with the hut, Cheeky Hut or whatever you want to call it. So that's what he had to do, get a building permit for that building that's already on his property. And in his motion, he is telling you that he's asking for additional time so that he can move that Cheeky Hut to a different location on his property.
All right. Mr. Vestgarden, I'll go back to you then. What's been the delay in getting, I understand your argument that the city has changed its ordinances or made a change to allow the Cheeky Hut, but you need to pull a permit. What's the issue in the delay in pulling the permit? Why do you need another 90 days?
So I applied for a permit, and so there's two things going on. Right now, it's functioning as a playground, which is no permit required. But then Mr. Trask required me to come with plans for a residential playground. And I asked the city for an example. Since he's requesting it, I assume that's something he asked for. The city asks for everyone that does a residential playground. If not, it's a discrimination. And they couldn't provide me a sample. I reached out to a lot of engineers. I went to engineering school, so I reached out to a lot of engineers that are throughout the country and in the Tampa Bay. No one's ever dealt with a plan for a residential playground, so no one can really give me an example of what the city is looking for. On a parallel, I applied for the permit for a shaded structure within the new city code where they allowed to build those now. So on a parallel, I'm applying for that permit as well. And that's pending. It's at review at the city.
Okay, so you've already applied for that permit. It just hasn't been issued yet?
Yes.
All right. Mr. Trask, back to you. If the permit that, and if you need to talk to any of the city staff while I'm asking you, please feel free to do so. The permit that he's applied for, the second one, which deals with the Cheeky Hut, number one, is that your understanding as well that that permit has been submitted to the city, and what would be the turnaround time for that permit?
So I'm going to hand this over to Marcy. She's been sworn in, and we're talking about the application itself. Marcy, has there been an application to move the Cheeky Hut?
So that's kind of what I was looking for clarification on with the permit that he submitted. There is a new hut depicted on the plans, but there was no confirmation if that was a brand new one or one to relocate. And it seems like there's been conversation where it was originally going to be relocated. Then the existing one was going to actually not be relocated and be turned into a playground. So it's been a little bit confusing. So in order to issue the permit for this new Cheeky Hut, I asked for confirmation on, are we relocating the existing one, or are we leaving one, are we arguing to leave the existing one there because it's a playground and now we're building a new one? So it's just kind of gotten kind of a little just weird sideways, to be honest with you. So we were looking for clarification before I issued him a permit for that one, because I couldn't really discern exactly what was going to happen in the backyard.
All right, Mr. Vestgarden, what's the answer to that question? Are you building two Cheeky Huts, or we just have the one there and we're trying to get it permitted?
So long story short, I sent an email answering those questions about a week or two ago, 10 days ago. So there is an email answering all those questions. The hut is currently being used by my daughter as a playground. The city ordinance says you can build a playground anywhere you want in your property. So I'm saying this is a playground. I'm going to do a climbing wall. I'm going to do a swing set, the ninja ropes, all that stuff, so she can play in it. If the city allows a playground according to the city ordinance, that will become her playground. If not, I'm going to move it to another part of the property and make it into a playground at another part of my property.
Okay, so I think the answer to the question is there's gonna be one Cheeky Hut, and you're telling me this
Yep.
isn't going over an outdoor kitchen. This is, you want to make it a playground.
Yep.
Okay, even if you get the application to have the cheeky hut there in your backyard, you're not gonna use it to cover anything, you're gonna use it as a playground.
Yeah,
Okay. Mr. Trask, I guess I'll start with you. Assuming that the applicant does what he says and he's applied for a playground, how much time would it need, would the city need to process, reasonably need to process that application, one way or the other, approval or denial?
I'd ask Marcy. I don't know the answer to that question.
So, to Tom's point, children's playgrounds do not require a permit. But I don't know how we go from it being a designated cheeky hut to now just calling it something different and adding more features to it. I just don't know how to move forward, honestly, with that aspect of it. As far as, just calling it something different and adding a few features, I just like we would be very careful with, how we proceed forward. I have no issue with getting him there. I just don't know that how I justify calling it a cheeky hut and then just changing what we're calling it and adding more features to it solves the problem. So I'm a little concerned about that part of it. And so honestly, at that point in time, I'd probably have to lean on Tom for some legal input on it. It just puts me in an awkward situation in how I'm viewing the permit.
So there's outstanding information that you need to process the application for the building permit. Is that what you're telling the special magistrate?
Yeah, I think it would be helpful if we could visit the site. Maybe I could better understand what it is. I know you did send some pictures, but contrasting that with what was constructed there as the cheeky hut and the features underneath, I just would feel more comfortable if I could put my eyes on it, have better clarity, work with you on getting the solution, getting you a new cheeky hut. I think if we work together and I can get on site and do that, I think there's some reasonableness. So I think for that part, time would be necessary. If we can move in that direction, if you're okay with a site visit and working through that.
I'm okay with that.
I guess, Mr. Vescar, what I'm struggling with is, if I recall correctly, this was a, cheeky hut that was built over, I thought it was an outdoor kitchen, but I might be getting it confused with something else. I don't recall you ever arguing earlier in our earlier hearings that this was truly a playground. I thought you said, and I got your argument. I mean, I understood your argument. The city was making, going through changes. You thought that these were permitted all over the city and hadn't been approved. I followed all your arguments, but I'm struggling with this playground because I don't recall you ever arguing that this was a playground before. I recall the previous arguments were this is a cheeky hut. It should be allowed because the city is going to address this issue, number one, and number two, there's cheeky huts all over the place. And I think number three argument was that this was put by the indigenous Seminole tribe and didn't require a permit. I think those are the arguments as I recall you making. And so, I'm not trying, I'm going to try to give you, I'm going to give you more time. I mean, the city's
Yeah,
saying they're
yeah.
willing to work with you. But what I don't want to do is be back here 3 months from now because you say this is a playground and it's being used to cover an outdoor kitchen and we're back here on some kind of use issue. I want to, you seem to be wanting to come into compliance. I want you to come into compliance. The city wants you to come into compliance. So are we really talking about a playground here or are we talking about a cheeky hut to cover your outdoor kitchen?
So in the original hearing, the first hearing, I did argue the playground and got dismissed by Mr. Trask. It's all on video, so you can review that video and you see that I argued it. And he just shut it down. So my daughter already uses it as playground. She uses the rafters as monkey bars and she climbs around and she wants swing sets in there. Since I can't utilize it for what I intended it for, she may as well utilize it for what she wants it for. So.
But are you being told that you can't utilize it to cover your outdoor kitchen? I mean, because
Yes.
I'm not hearing, that the city's told you that?
Yes.
Okay.
Yeah.
I mean, I just don't recall that, but
Yeah,
again,
yeah.
maybe that wasn't an argument that was made. Mr. Trask, do you want to add anything to this conversation? I know I asked him a few questions.
I don't have anything to add. I just think that the ball keeps moving in a different direction based upon the input that he's getting. And
So-
we would just like him to file a building permit application with a plan with everything that he plans to do. And then we can make a determination whether or not it meets city code. And if it does, he'll get his permit. If it doesn't, we'll tell him that we can't issue the permit.
Great.
But the order of the special magistrate is obtain a building permit.
Go ahead, Ms. Forbes.
So what I was however, it didn't meet the setback requirements even for our new code. I can't remember if there was a height issue as well, but there was at least one component that deemed it not able to be permitted as a cheeky hut structure in that location. So that's when it morphed into either relocating it or building a new one somewhere on site where it would be permissible. So that's kind of where he did try to submit a permit, but it doesn't meet our criteria.
All right, here's what I'm gonna do. Mr. Vestgarten, I'm gonna grant your motion for 30 days, not 90 days, 30 days. Again, I'm here whatever this is, the third Monday of the month, so you can come back before me. Maybe 30 days to try to work with the city. I would encourage you to make an appointment and come in versus email. I'm sure the cities like the rest of us, they get inundated by emails. I think it'd be more efficient for you to try to come in and make an appointment and talk with them. So I'm gonna give you 30 days to do that. My concern is that, even if this thing is a playground, I mean, I think you're gonna be back here before me if you try to make this thing into a playground and it's not really a playground. If there's a setback issue or something like that, I also sit and consider variances. I don't know whether this would qualify for a variance or not. I don't know. But I would encourage you to work with the city on this and see if you guys can work it out. I'll give you 30 more days to do it. And if that doesn't cut it, then you can come back before me and see me again.
Thank you.
All right. Okay. Anything else on that one, Mr. Trask?
No.
All right, I'll prepare just a simple order, 30 days. I'm not going to set another hearing on that. If the city needs to set a hearing on it, we can certainly do so. All right, we'll go on to the next case, which is case number 2023.3699 for the property located at 314 129th Avenue. All right, Mr. Trask, I understand this one. I read through the agenda materials. I understand there was a letter sent from, I assume this person is somehow the manager of the LLC or the owner of the LLC that is the respondent. So Mr. Trask, how does the city want to proceed on interpreting this letter that he sent and dealing with whatever procedural due process issues he raised or anything else?
Well, first of all, Mr. Carnes is in the audience. Mr. Carnes has been given the authority by Mr. Wolfson to appear on his behalf and speak on this particular issue. So I'm going to let him step forward. I'm going to need to swear him in, though. He's the individual I said I needed to swear in. But the city was being careful, even though we believe that we've got proper service on the LLC Paradox. We wanted to make sure that if Mr. Wolfson had any arguments other than proper service, that he would have them addressed today.
All right, Mr. Carnes, come on forward. Give us your address, your affiliation. Well, first of all, go ahead and swear him in, Mr. Trask.
Could you raise your hand? You swear the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, Mr. Carnes, what's your address and what is your affiliation with the entity here that is the respondent? It's Paradox LLC.
So my name's William Carnes. My address is 400 150th Avenue, Unit 400, Madeira Beach, Florida. I'm the owner's representative for Paradox. And they have adjoining properties that I'm a general contractor and a developer. They have a permit application in for a 10-unit building right on the adjoining property to there. So I'll be building that for them. So
All right, well, Mr.
there's
Carnes.
two
yeah.
things I'm here to discuss.
Okay, go ahead.
Number one, I disagree with Tom. I don't believe that notice was given properly due to it was sent to an old address, was not sent to his new address. There was one address on the property appraiser's report. And there's another address, which was his old address, which was on Sunbiz. I believe the city picked it up from Sunbiz and not but that's not here nor there. My client is ready, willing, and able to comply with the order one of the things he was worried about in redeveloping, he owns that parcel of property there, and then just to the left of it, he owns that parcel. He's in the process of trying to build another, it's zoned for 9 units, but due to structure and how it's built, there's only gonna be 8 units, but he's in the process of doing that, and he was worried about setback, and if he tore that structure down, that it would create a setback issue, because it's, my understanding is the existing setbacks are grandfathered in. Having studied all of that and worked with the architect, I don't believe he's gonna have any structure, any setback issues at all. What we're asking today is some time, because by the time he received the notice, you had already had your meeting, your last meeting, and said, I think it was $250 a day or something like that was the penalty for it. I want to make sure 2 things. Number one, not interested in paying $250 a day for it not being compliant due to the fact that I don't believe the notice, but I'm not an attorney, was properly served. I have JVS demolition, local company here, tears down hundreds of buildings for me. And I've already reached out to them. We want to get the building demoed. He just doesn't know if he has to get the asbestos notification. There's 2 10-day periods there that are required, plus the time that it would take to do any remediation before that building gets torn down. So what I'd like to do is get a 45-day extension to get this permitted and get it down. JVS can get a permit over the counter, I believe, for the next day. I think it's, I don't know if it's a residential structure. I know there's multiple units in there, so I don't know how they deem that, but either way, we'll get the building down, like I said, within the next 45 days.
All right, thank you, Mr. Carnes. Mr. Trask, this is kind of one of these hybrid things where it's, I think more argument than anything else, but I'll give you the opportunity. Do you want to cross-examine Mr. Carnes on anything or ask him any questions? Just anything? Okay. All right, Mr. Carnes, just stay there. Mr. Trask, how do you want me to deal with that? I mean, I certainly, I don't know about the notice issue and the mailing. I mean, I recall it was posted at the property. I recall it was posted at City Hall. I found notice was proper. So
He
unless
lives
the
in
city wants,
Chicago, though.
I got it, but unless the city wants me to revisit my ruling based on those procedural due process, I do believe there's a valid basis for notice. At the same time, if the city wants to reset this for hearing and believes there's a notice issue that needs to be cured, we can do that as well. So how's the city want to proceed on this one?
We can proceed today, and do the case all over again. If that's, I would prefer to do it today than to set it off another 30 days, since this is a life safety issue. This is a building that basically needs to come down immediately. And if we send it out another 30 days, then we're going to be back here with the same arguments. But I do have the packet that was received into evidence. I'll go ahead and provide that to you. And I have an additional one for Mr. Carnes, if you'd like it.
All right, well, why don't we do that, Mr. Trask? I think that's a good solution, since the owner definitely has a representative here today. So, Mr. Carnes, what we're going to do is so that you can address any argument that the city makes in regard to this proceeding, we'll go ahead and have the city present its evidence of the violation, and then you'll have the right to cross-examine the witnesses. I certainly understand what you're saying, and that.
We're not disputing that anything, that it's not conforming, it needs to come down, and we want to get in compliance with it. So there's no issue in regards to whether we want to tear it down or not. We want to tear it down. We want to tear it down ASAP. So I don't know if we need to
I'll defer to Mr. Trask as to how he wants to.
do that whole
handle it.
exercise or not, because I'm standing here saying we're guilty, we didn't tear it down. I'm just saying we didn't receive that notice, and I didn't get it until after the hearing. But I can tell you, I do a tremendous amount of building and development around here. I assure you that the structure is going to come down I'd like 45 days is what I'd like, just in case of that asbestos issue. But if there isn't a need for that asbestos, there's no reason why we can't have this building down in the next couple of weeks. So I'm ready, willing, and able to perform.
Before I move forward with putting on Grace to prove up the case, Mr. Carnes, we can go through this case all over again like we did the last month, or you can just waive the argument that the proper service was not given. That's the argument right now that we're facing in this letter that was written.
Mhm.
So if you waive that on behalf of the property owner, we can move forward and talk about timing. But if you're not willing to waive that notice issue that he raised, then I need to go ahead and put on the witness and we'll try the case all over again right now.
Well,
So.
I have no issues with moving forward and waiving my right. I just want to make sure that I can.
Well,
let
I'm
the
not saying you're waiving
proper
any rights. I'm
amount of
saying that
time. No,
I
to the
need you to
notice. I'm
put on
saying.
the record that you're waiving the notice argument that was in the email that was sent by Mr. Wolfson. Either a yes or a no, and we can go from there.
Well, if I'm not being fined, then I'd say I'd waive it. But if that fine stays intact, then I don't want to waive it.
Okay, we're going to go ahead and put on the case then. So
So you're saying that you're gonna confine this gentleman?
what I'm saying is we're going to go ahead and do the case over with right now so we can address the notice issue.
Okay.
Okay. You can have the seat, Mr. Carnes. It'll be a couple of minutes. Thank you. All right, the city would call Grace Mills. Grace, if you could state your name and your occupation here at the city of Madeira Beach.
My name is Grace Mills. I'm a code compliance officer for the city of Madeira Beach.
Okay. Are you familiar with this property located at 314 129th Avenue East here in
Yes.
Madeira Beach?
Yes,
Okay. Is this a proactive case or was this complaint driven?
this is proactive.
Okay. And when you say proactive, was this a proactive case on your behalf or was it another city employee?
It was another city employee, Mr. DeSantis.
And he brought the property to your attention?
Correct.
Okay. And when did you go out to the property to determine whether or not that there was a violation at that property at 314 129th Avenue East?
The date that Mr. DeSantis was out there on the property to determine if there was or not a violations was August 21st of last year.
Okay, so almost an entire year ago.
Correct.
Okay. And when you went out to the property, what violation did you determine existed on the property?
There were multiple that I can state from the letter if we want to go through that.
Yes.
Starting with the first courtesy letter, it was sent November 1st, 2023. And it stated the declaration of an unfit structure for what we posted. It also had exterior maintenance, overhanging and overhead loose objects on the property. There was also evidence of insect infestation within the walls, which is as well. Floors, interior walls, and ceilings of the structures had some damage to them. Floors, would you like me to read out each ordinance for you? What would be easier?
No, I just want you to tell me generally what you found out there, and we'll talk about the ordinance sections later.
Okay, might be easier to go through the photos then in that case. Let's see. So as you can see in a few photos, supporting beams.
Okay, hang on a second. So on each one of these pages, I'd like you to note the page number in the packet that we have, and then tell me what you're seeing as a violation of the city code.
16 is the first page that I'll start with. I think that's one of the rear patios. Loose overhang in the upper hand corner on the right. A supporting beam in the center that has some deterioration on it, which is a structural member. 17 is a shot from below onto the second level. You can see that the overhang is badly deteriorated, some loose objects as well. 18 is an interior photo of the flooring, just showing that it's a pretty bad state of disrepair. 19 is one of the walls. I believe this is on the first floor. There seems to be some leakage there. 20 is depicting a ceiling on the property. I don't know if that's water damage or some kind of intrusion. 21 is just showing the backyard, vacant. 22 is actually depicting, I believe those were bees by Mr. DeSantis that he quoted that were actually inside of the walls and in the interior of the property. 23 is actually just depicting the outdated electricity on the property. No deterioration or anything there. 24 is the second story balcony with some deterioration. Mr. DeSantis felt that it wasn't safe to even walk on, as that is a second story. 25 is, let me go down. I believe that's the floor underneath on the second story. And if you go to 26, that's the ceiling above it where you can actually see directly into the outside.
Okay, so once you went out to the property and found these violations, did you go back to your office and look up to see who the property owner was?
Yes,
Okay. And when you did your search of who the property owners, did you look at the tax collector and property appraisers websites?
I did, yes.
Okay. And if you could turn to page 3 of the packet.
Yes,
So is this a printout from the property appraiser's office?
that's correct.
And where does it reflect that the mailing address is?
149 Oak Knoll Terrace of Highland Park, Illinois.
Okay. And is that where you sent your notices in this case?
Yes,
Okay. And I'd also like you to turn to page 8 of the packet.
8,
8.
yes,
So you went to sunbiz.org to determine where the registered agent has its address. Is that correct?
that's correct, yeah.
And what address was listed on Sunbiz?
That was of July 19th of this year. It reflected 149 Oak Knoll Terrace.
Is that the same address that you mentioned a moment ago?
Yes,
Okay. So you've issued a courtesy notice of code violation. I'd like you to turn to page 9 of the packet. When was that issued?
November 1st of 2023.
And did it list the code sections, if you can just go through those numbered code sections that were in violation on the property?
Yes, do you want me to read them off individually?
Just the code section numbers.
Section 1491, which is the unfit structure. Section 1469, maintenance of exterior premises. Section 1470, general maintenance.
Thank you. And did you ask the property owner to bring the property into compliance within a date certain?
Yes, and that date was November 15th of 2023.
Did it come into compliance by that date?
No,
Okay. When you sent the courtesy notice, did you attach to it the placard for unfit human occupancy and then all the photographs that you just went through a moment ago?
that's correct. The unfit for human occupancy is on page 12 and 13, and then the following photos were attached to the letter as well.
Okay. And since the property did not come into compliance by November 15th, did you issue a code violation notice?
I did, yes.
Okay. And what page is that in the packet?
That is page 27, starting on 27.
Okay, did you send that letter by regular mail and certified mail?
Yes, that's correct.
And did you send it to the address that you had mentioned that was at the tax collector in Sunbiz?
Yes, that's correct.
Okay. And in that notice of code violation, did you set a date certain for the property to come into compliance?
I did. That date's November 29th of 2023.
And obviously didn't come into compliance by that date?
It did not.
And then you issued a notice of hearing, a statement of violation request for hearing in this case to bring it to the special magistrate?
Yes, that is correct. And that was sent July 19th, 2024.
Okay, and that's on pages 48 and 49 of the packet?
Correct.
Okay. And did you set forth the same code sections that you cited earlier, which is 1491, 1469, and 1470?
That's correct.
All right. And did you issue a notice of hearing for the 29th day of July?
Yes, that's correct. On July 19th, 2024.
Okay. And with regard to today's hearing, well, let me just finish this packet, then we'll go to today's hearing. Now, when the notice of hearing was prepared, did you actually send it by regular mail and certified mail?
Both, yes.
Okay. And did you also post the property?
Yes.
And you issued an affidavit of service reflecting that you posted the property as well?
Yes, there's actually a photo of the property posted on July 19th.
Okay, and that is on page 57 of the packet?
Yes, that's correct.
Did you also post it at City Hall?
Yes, that's reflected on page 58.
Okay, and with regard to today's hearing, after you received the letter from Mr. Wolfson, did you issue a notice of hearing for today?
Yes.
Okay, and if you could look in the packet that we've got for today's hearing on page 74, is that the notice of hearing that you gave to Paradox LLC?
Yes, that was sent regular and certified mail.
Okay, now there's a different address.
Correct.
And where did you get this address for this notice, 5837 Teal Lane, Long Grove, Illinois?
That was sent via email. He let us know about that and then going to the property appraiser for an updated version.
Okay, when you say he, you mean
Oh,
Mr. Wolfson?
Yes.
Okay, and that was also referenced in his letter or his email that he sent to you on page 75 and 76?
Correct, yes.
Okay. So you issued the notice of hearing. Did you also post the property?
Yes, I did.
Okay, and when did you post the property?
Let me get down to that just one moment. That would have been August 15th of 2024.
Okay, and that's a picture of it on page 82 of the packet?
That's correct.
And did you also post it at City Hall?
Yes, page 83, and it was August 15th as well.
Okay. And then once you did that, you issued an affidavit of service, which is reflected on pages 72 and 73, correct?
Yes,
And that affidavit shows that you sent the notice of hearing by regular mail, by certified mail, and you posted the property of the most recent notice of hearing, correct?
that is correct, yes.
Okay. And the property is still not in compliance, correct?
Correct.
Okay. Has there anything been done on the property since the last hearing that we had on this case?
There has not, no.
Okay. All right. Those are all the questions I have for Ms. Mills. I would tender into evidence the packet from the last meeting, which was pages 3 through 58. And I'd also tender into evidence the packet for today's hearing, which is pages 72 through 83 of the agenda packet for today.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 3 through 58 of the original agenda packet, as well as pages 72 through 83 of today's packet. All right, Mr. Carnes, this is your opportunity to cross-examine Ms. Mills. You don't have to ask her any questions, but this is your opportunity to ask her any questions. I'm going to give you the opportunity in just a few minutes to tell me anything else you want to tell me, but do you have any questions for Ms. Mills this time?
Only question I have is, I don't know what date she had for, you said there was November was the first notice that you had sent out, is that correct?
That's
November,
correct, yep.
November 23?
The first notice, let me go back to that.
Mr. Carnes, I'm looking at a printout from the property appraiser's website dated November 1st, 2023 at 1:20 PM, and it lists the 149 Oak Knoll Terrace address as the mailing address for the owner,
Okay,
and the printout.
what was the address again?
Sure, that was the 149 Oak Knoll Terrace.
Right, that's the incorrect address.
Okay, and that, well, according to the property appraiser's website, as of November 1st of 2023, the owner, Paradox LLC, was still listing that as its mailing address.
Yeah, I
And
don't
then
know
there's
when it,
also the printout from the Sunbiz. So Paradox LLC apparently tried to do some kind of filing with the state. And that was dated July 19th, 2024. So that's just about a month ago. And that also lists 149 Oak Knoll Terrace, Highland Park, Illinois. That helps your questioning of Ms. Mills.
and that was picked up off of the property appraisers in.
No, sir, Sunbiz. So that's the
Sunbiz.
Division of
Okay.
Corporations with the
Yeah,
Department of
I'm
State.
familiar with it. I'm familiar with it. So I don't know when, date-wise, because I don't have it and I don't think you have it either. I don't know when it changed on the property appraisers, what date that was. But once again, the correct address is the last notice that you sent out.
And Mr. Carnes, I don't want to derail you. This was your opportunity to ask Ms. Mills some questions. So do you have any more questions for her?
I don't think so.
Okay, no problem. All right, thank you, sir. Mr. Trask, is there any other witness the city wants to call?
The city has no other witnesses on this case.
All right, sounds good. Mr. Carnes, this is your opportunity to tell me anything at all you want to tell me about this particular violation. Make any arguments you want to make, provide me with any documents, or call any witnesses that you'd like to call.
I have no witnesses. I just, again, as I stated, I don't know when the address got changed and whose responsibility it is to change it. I just know that from what Ivan Wolfson has explained to me, that it went to the wrong address. He never received it until after you made your notice. I have the correct address here as 5837 Teal Lane, Long Grove, Illinois. I believe that is the address that you got off of the property appraisers to send this last notice out. So once again, we stand here ready, willing, and able to comply. Because of the address snafu or whatever, I wasn't involved back then. I don't think it's right for Mr. Wolfson to be charged a daily fee when he's ready, willing, and able to perform, and he's engaged me and to do that, and that's exactly what I'm gonna do, so. And get it torn down just as quickly as possible.
All right, thank you, Mr. Carnes. Mr. Trask, do you have any questions for Mr. Carnes?
I do, Mr. Carnes. Have you been out to the property?
I was just there the other day and it's in bad shape.
Okay, were you out there in August of last year when the city first cited the property owner?
2023, no, I'm not. I do
Okay.
own property across the street from there, but I had no idea who owned that at the time.
Okay, when was your first time that you saw this property? How many months ago?
Oh, just about 3 weeks ago.
3 weeks ago,
Yeah,
okay. All right,
after,
I'm sorry, I thought-
after he got the notice, he called me and asked me if I could help. I told him I'd be more than happy to help him get it down.
Okay, all right. So did Mr. Wolfson receive the notice of hearing for today's hearing?
He did.
Okay, and that's the reason you're here talking on his behalf?
That's correct.
He just couldn't fly down here from Illinois to make it
He
on
could
time?
not.
Okay, all right. And so you don't disagree that the property is in violation of those 3 code sections right now, correct?
Oh, no,
Okay, and you don't disagree that the house needs to be demolished?
no,
Okay,
it's ready to go.
okay. And you don't disagree that a building permit for demolition can be obtained from the city within 24 to 48 hours because it's an over-the-counter permit, correct?
I believe that's correct. And if that's the case without the asbestos inspection, then we could get it probably torn down next week. But
Okay,
I just don't know if maybe Marcy knows if that type of property. I know when I tear down, I've torn down a ton of commercial
all right.
buildings.
You've answered my question on that. Thank you. So are you purchasing this property so that we can know for sure that the property is going to be torn down based upon your representations today? Because Mr. Wolfson is the owner of the property, you're not.
That's correct.
Yeah.
So Mr. Wolfson has engaged me for 2 things. One, to address this issue and get it demolished ASAP. He's engaged me to do the development services that are necessary for that property and the adjoining property so that he can build a 8-unit building there. He's also engaged me to be the developer and the general contractor on the property that he owns at 310. I think it's 310.
Okay, so you don't have any intention of purchasing the property. You're doing
No,
this
no, no.
all-
This
all
is
as a business relationship, contractor, developer, that type of thing.
correct.
Okay,
I've
understood.
been paid to be his general contractor and his developer.
Gotcha. Okay. All right, I don't have any other questions of Mr. Carnes. Thank you.
All right, I don't have any questions for you either, Mr. Carnes. Anything else you want to tell me today?
No, I remember a guy told me years ago, a word is called rockmonus. And I said, I don't know what rockmonus is. And he says, well, in my language, it's have mercy on me, have pity on me. So I'm here asking you for some rockmonus today.
Thank you, Mr. Carnes. I do appreciate that and appreciate you coming and appearing on behalf of the respondent today. All right, this is the opportunity for public comment. Is there any member of the public that would like to come forward and provide public comment about this code violation here today? Okay, seeing none, we'll go ahead and close public comment. All right, Mr. Trask, anything else?
I just want to, just to go over a couple of things. So the property has been in this state of needing to be demolished for over a year. So it's been sitting there, and the property owner has been aware of it for over a year because of the prior notices. So, and the property owner's representative, Mr. Carnes, is admitted to the violations, admitted that the property needs to be demolished, and has requested a 45-day time period in which to get the demolition completed. The city has no objection to the 45 days that Mr. Carnes has requested to bring the property into compliance. But we would ask that you establish the same dollar amount of fine, $250 a day, should the property not be brought into compliance within 45 days of today, not 45 days from the date of the order, but 45 days from today, should you find that the violation exists on the property. We are very, very concerned about the status of this property, and it's been sitting so long. And so I'm just kind of just throwing out there that if Mr. Carnes comes back at day 45 and needs more time to complete this, that we would be requesting for additional protections to the public, and that would be things such as fencing the property off with opaque chain link fence, removing the water meter, removing the power, boarding up the doors and windows, that type of thing. So we're not asking for that at this point, but if he fails to do it within 45 days, and he comes back here for an extension, we'll definitely be requesting that for protection of the public.
All right, and Mr. Trask, how do you want me to?
Process.
So this would require
I got you, Mr. Carnes.
maybe quashing the prior order
Okay,
and entering the new order. I don't think that the prior one needs to be amended, as an example. I think it should be quashed and then have this order issued. Then there would be no questions about proper service.
all right, yeah, what I'll do is I'll set aside the prior order, enter this new order with 45 days, $250 a day thereafter. I'm gonna do it a date certain. I just looked on my phone. It looks like 45 days from today is October 10th, 2024. You guys want to check me on that real quick? Just want to make sure my phone didn't go haywire on me. Okay, I'm going to go ahead and enter a date certain so that the property must be in compliance by October 10th, 2024, or thereafter it'll be a $250 a day fine. I'm going to set aside the prior order, enter a new order, finding there is a violation. I do find, based upon the admission of the respondent or the representative of the respondent, as well as the evidence in the packet and the testimony of Ms. Mills, that there is indeed a violation of all ordinance sections raised in the notice of hearing, and that the proper corrective action on the record is to demolish the property, which the representative of the owner and respondent has admitted to. All right. Mr. Carnes, anything else you want to tell me before I close the hearing today?
Very much.
All right.
I'm sure you'll be done well before that time frame. Thank you
All
very
right.
much.
Mr. Trask, anything else before me today?
No, thank you.
All right. That concludes today's
Thank
special
you.
magistrate hearing.